exactly this order today that came to the fore from the Allahabad High Court does for this particular case. Now, it may have limited repercussions as far as this particular cellar goes, but now we have the Masjid side going on to knock on the doors of the Supreme Court, even when today the High Court said that your case has no merit. It has weak legal standing. There is enough and more documentary evidence, at least as far as this cellar is concerned, to show that the possession was always with the Hindu family, which was the Vyas family.
This is the statutory and fundamental right of every citizen of India to approach the highest court.
Sure.
In fact, there is hierarchy of judiciary. If one court decides a particular thing, then the rooms are always open for filing appeal. And thereafter, before the revision bench, and thereafter before the Honorable Supreme Court of India. So this is in fact provided in the Constitution, in the law. This is a scheme of the law. So no one should be perturbed if the Muslim party is approaching Honorable Supreme Court, or if they, I mean to say my Hindu brothers, approach the district court. At last, the rule of law has to prevail. At last, the verdict given by or propounded by Honorable Supreme Court has to be this accorded finality. So we all have been waiting. We all have been waiting. This is the one side. The other side is that, then for what? 1991 Place of Worship Act was enacted, and as long as that act is in force, my submission is, my take is that passing of a judgment pertaining to any mosque, any gurudwara, any mandir is absolutely illegal, and that contravenes the Place of Worship 1991. Because as long as same is a good law, same is a good act, then no one can pass any of the order, any of the judgment. So Honorable Supreme Court has to be knocked for this purpose.
Sure, and absolutely. Nobody is perturbed here. Everybody has the right to approach and explore all their legal options. There's absolutely nothing wrong with that. But many are asking the question.
Only the anchors are perturbed.
No, absolutely not, sir. Absolutely not. There are many who are asking.
We are not perturbed.
Absolutely not. There are many who are asking that is this being dragged on for much longer than it really should be? That's the question many are asking, which is why I asked you that. But let me also get in Kapil Sankla, who's with us on this broadcast. And Kapil Sankla, the 1991 POW Act is being spoken of. Is that an argument that will hold water as far as this particular case is concerned? Because while this case has been heard in different courts of this country, the Allahabad High Court on one occasion has also gone on to note that there is no material evidence on record, at least, that goes on to talk of a formation of a Waqf board or the creation of a mosque in this particular site.
Well, not only that, what is really interested is, as far as the act is concerned, and at various forums I have questioned the act, because the act basically creates a status quo. And we know that even the Honorable Supreme Court says that in civil cases or other cases, status quo should be for 6 months and then should be decided on merits. And here the act itself says, let's have a status quo and let us not disturb the status quo, which basically means that if there is a wound, let us leave the wound and let us not heal the wound. So as far as the status quo is concerned, in this case, that doesn't even help the other side, and the reason is this. Because since 1991, at least the Vyas family has challenged the right of the mosque to exist there. Since 1881, they have the documents to show that they are in possession of the basement of the Tehkhana, and that the southern side of the Tehkhana, the puja has been done consistently. Now for a moment, just think, if you're talking about status quo, what are we saying? That the mosque on the top and the mandir at the bottom should remain the way it is, and that in the light of the fact that the 4 ladies who had filed the case saying that once in a year they were allowed to do puja and once in a day they were allowed to enter the sanctum to do puja should also be permitted, that cannot be. And the purpose of the, now let us go at the purpose of the act. The purpose of the act is, if some place has been converted into another religious place, then that should not be disturbed. In this particular case, the temple has not been completely destroyed. It still exists. Not only it exists and there is a Shivlingam there, but also puja is consistently done and is sanctified as far as Hindu rituals are concerned. So as far as the act is concerned, that act does not help them, though I personally believe that act is a bad act and it basically festers wounds forever. But the second part of it is that since Vyas family, as far as the possessory right is concerned, are winning on 2 fronts. One, that they have documents since 1881 to show that they have been in litigation fighting or have a contentious issue with the mosque saying that this mosque should not exist, and that at least till 1993 admittedly, as the case of the parties are, that they were doing puja in that area and they still possess certain parts of the basement, which, as somebody just said, Mulayam Singh government just put some iron claddings in front and shut it down. But the property is still owned by them, the possession is owned by them, puja is still conducted there. Then how can you take away that right? So at the end, the only important aspect is this, that yes, any party in India has the right to go to the Honorable Supreme Court, but the orders of the District Court and the High Court are clear and based on cogent evidence and a clear interpretation of what the law is on the fact that the Vyas family has asserted their rights since time immemorial.
But Kapil Sangla, do you then think this is going to have repercussions or implications on the larger suit that is being fought as well?
Oh, I definitely think so, and I say this for two reasons. One, on your channel I had already said this when we were speaking about the 4 ladies who had gone. I said that you have to see if there is cogent evidence to prove that the ladies were entering the premises and doing Hindu puja, then the question whether it is a mosque or not is a question that is a question on fact and also on the legal matrix as far as the law is concerned, and that has to be looked into, because if puja is being conducted, then it clearly is not a mosque, it is just a building in which namaz is being said or done, or whatever it is said to be done. And the second aspect is that as far as the property is concerned, now there is a question as to the ownership and occupation of the property. The Muslim side say our right emanates from a certain emperor who had come, broken down everything, built something. While the Vyas family says our right comes from, look at the khatas, look at the documents, look at the possessory rights and other documents that show that we are in possession. And third, as far as the religious sanctum is concerned, the fact that there are 3 sides, one a Muslim side that said that there is no Hindu artifact there, that was proven to be false, and now there are 2 Hindu sides. One says that I am doing puja at least till 1993 and I am still in occupation and ownership of a certain part of the premises, and the 4 ladies who say that every year we were allowed to enter and in any time once a day we were allowed to go there and do puja where there is a murti of Ma there, also shows without any inkling of doubt that the question of whether it is a absolute and 100% Muslim side is an argument that would fail in the longer run.
Shahid Ali, what do you have to say about that? Like I said, the High Court also has noted that there is no evidence on record. There is no evidence on record to talk of a work for the creation of a mosque. There are multiple testimonies that we've heard, documents that we've seen, pictures and maps that we've seen that all speak of a temple that existed there at some point. If that was the case and if it was demolished and a mosque was constructed there, that would be desecrated land. It can't be a mosque then in any case. Like Kapil Sangla was also talking of, that maybe it's just a building where prayers are being offered perhaps.
I'm really surprised. What kind of evidence they are talking about? Without the documents and the claim of either of the party. As long as the same is not tested.
So the Vyas family has given its evidence. Vyas cross-examination. If we will take about Vyas family as far as possession and occupation is concerned, they've given their evidence.
The final verdict is always rendered by the courts after the evidences are adduced by both the parties and evidence is appreciated. Where is the appreciation of evidences? You have been claiming a particular thing as evidence. You have been claiming
a document that is unchallenged.
Sir, Mr. Kapil,